Justice Sotomayor.
I find it strange that the district court and the court below did find a Title IX violation, but not an equal protection violation, and remanded for the equal protection violation. I'm not sure how it could do that, because it would seem to me that if the evidence is not sufficient to justify finding an equal protection violation, it's not sufficient to find a Title IX violation. Is that correct? At least on the record as it exists now.
Right, and so to be clear, the district court actually ruled for West Virginia on both Title IX and so the Fourth Circuit said you lose on Title IX and we're not sure about equal protection.
But assume the Fourth Circuit is right.
Right. Well, so in answer to your question, I think that doesn't make sense. And I think the reason why it doesn't make sense is because the Fourth Circuit effectively stripped out what they said is Title IX doesn't leave room for any kind of justification or any kind of analysis of what the reasons might have been for the state's action. And I think respectfully, particularly when you look at the regulations themselves, that actually does contemplate exactly that sort of analysis.
I agree with you on the regulations.
Right.
And so could you not have a Title IX violation but still have, let's assume, and I know you're going to fight the factual premise.
I'll try to embrace it, Your Honor.
All right, embrace it. All the scientific evidence showed that there's no difference between cisgender girls and trans girls. I know there's a fight about it.
It hurts.
I know it hurts. But assume it. Could you not still have violated? Could we hold that as the regulation stands, the regulation would permit you to discriminate, but the equal protection clause would not?
So let me try to get my head in the framework of assuming.
Assume.
I think the regulation would still allow us, under its express terms, right?
I'm assuming,
right.
Yes.
And so you're asking, even assuming our compliance with the regulation, could we still have a potential equal protection problem?
Yes.
In that world, I think we would still be fine under the equal protection analysis, frankly, for some of the reasons that you heard from the solicitor earlier today, where it's because even if you assume the heightened level of scrutiny, let's assume that we're in intermediate scrutiny world, it's still a reasonable fit. It's not a perfect fit.
Then we're back to that.
Exactly. And
right.
I know we've had a long colloquy about that today, but ultimately I think that's what
I just destroyed that by saying that the science has said there's no difference.
Well,
and we know that's not true. But assuming the science said there was no difference,
right.
How could you ever say it's reasonable?
So I'm assuming a world in which there's no difference between, so you're saying testosterone suppressed individuals? Is that?
No,
or you're saying all men and women full stop?
Right.
Oh, okay. Maybe I apologize for misunderstanding the hypo. If we're assuming a world in which there's really no biological difference, full stop, as to men and women, full stop, then I think, right, the legitimate governmental interest falls away. I agree with you.
Justice Kagan.